Welcome to Change Starts Here, brought to you by You Are Empowered. I'm Dr. Laverne.
I'm Dr. Marshadi, bringing you real people with real life stories in real time.
The power to make decisions for another human being takes great responsibility. What happens when the patient's interest and autonomy collides? Today we have Dr. Indran Chetty to help us solve this dilemma. Dr. Chetty is the academic head of Division Forensic Psychiatry at WITS. Welcome, Indran.
Thank you.
But before we explore this further, the tea smells divine, Shadi. What have you brewed for us today?
So today is a wintry kind of tea. I was inspired by glühwein, but it's a non-alcoholic glühwein. So I've used grape juice instead, pomegranate juice, star anise, cinnamon, cloves, and a slice of orange. Please enjoy.
Lovely, let's have a sip. It smells lovely. Excellent. Lovely, thank you.
Or maybe I should have added the wine.
Absolutely. Indran, tell us a little bit about yourself first. Why forensic psychiatry and why forensic psychiatry?
So I think my career probably can be defined as just things that have happened along the way. Obviously, medicine was a very considered decision because that takes planning. But thereafter, worked in general practice and then decided to specialize. And even that wasn't really sure. Got into training post and completed it. And then realized that I really found the space that I was enjoying in medicine. And then worked, and I'm someone who constantly reinvents in a career. And after many years of private practice, decided to get back to state. But prior to that, completed my LLB part-time at UKZN and always had an interest in the law. So also forensic psychiatry allows me to marry the law and the medicine or the psychiatry. And then now I work exclusively in forensic psychiatry, which is the best place for me to be because I'm able to use both those.
Sure. I think you're probably unique in that you have that combination.
There's one other psychiatrist that I know of who's got an LLB.
Okay.
Yeah.
Oh, fantastic.
And now, following on that, having that unique double qualification, how does it better equip you to engage in forensic psychiatry?
As you know, psychiatry as a whole, just general psychiatry, involves lots of legal issues because of the nature of the patients we see. And then just the practice of psychiatry is regulated, as you know, by the Mental Health Care Act and other relevant laws. So we really can't practice psychiatry without some knowledge of the law. Obviously, forensic psychiatry works at a sort of parallel space. But I think just having the knowledge makes it easier to negotiate that. I think as doctors, we all know that we can be very apprehensive when we deal with legal issues in patients. And then so for me, just having that background as a solid foundation really helps to maybe overcome some of that anxiety. Not that it's a necessity, but I think it does help.
Absolutely meaningful. I mean, we are known over the ages for controversy, and one of the things that to this day people think we do is lock people up without their permission, intervene in their lives without their permission. Straitjackets, asylums, and so forth. So how does autonomy feature in psychiatry in the modern times?
So what we do is very regulated, be it general or forensic psychiatry, and it's not just about the psychiatrist making a decision. And I think if we speak about autonomy, it really speaks to issues of ethics and human rights in medicine and psychiatry. Autonomy is especially important in psychiatry because it speaks directly to some of the diagnoses and disorders that we manage, and then when patients then get to a point where they lack autonomy. And I think if you lack autonomy, then it impacts directly on just everyday life and the decisions we need to make, be that decisions about our financial affairs, about our care, about legal matters. And we've all been faced with those conundrums where we wonder how can we best take steps to protect patients who are facing those areas. So we don't just make arbitrary decisions. It's very regulated, but I think it's very necessary.
Can you give us some instances where in your practice you've had to look at whether someone has capacity or autonomy? Just a case scenario for us.
Sure. So I think one of the major areas that we work in are elderly patients with the diagnosis of dementia, also known as a major neurocognitive disorder in psychiatry. And that's where someone's, or essentially their cognitive capacities can be impacted, but various other functions as well. But at the heart of it, a change or a deterioration in their cognitive functioning, and obviously by that related to their decision-making, how they understand things and how they are able to make decisions with information they are given. Now, as we mentioned earlier, decisions about financial affairs, about personal care and other matters. So we've had many instances where we are referred patients who their primary caring doctors believe that there may be a problem with a deterioration in capacity, and then a psychiatrist would need to make an assessment of this to give an independent report. Now, an independent report would involve a doctor or a psychiatrist who is not managing the patient, so there's no conflict of interest. And the things we really look for is ability to understand information, to then assimilate that information with what you know about your affairs, use that information to then make decisions, specific decisions about your well-being and your affairs. And then, so that would be one of the major areas in which we would look at assessing patients' autonomy by way of their decision-making capacity and then making a recommendation. Also, just to add that the assessment of capacity is very specific to task. So it's task specific. We can't simply say that because I don't have capacity to make, probably carry out one function, then I don't have capacity in every other area. We need to specifically investigate each areas and the decision making and then comment.
Okay. And that leads then to the concept of a curatorship that would be applied to a patient. As I understand, there's different kinds of curatorship. When would one apply?
Yeah. So essentially there's 3 types of curatorships that the court would need to inquire in with the assistance of medical reports and then other information that may come forth. So we get a curator ad litem that deals with a person's legal affairs when they don't have capacity to be in court themselves. Then a curator bonus that deals with the financial and other affairs of a patient, and then the curator ad personam that deals with just basic decisions about living and care and that type of thing. Now, sometimes someone needs all 3 types of curatorships, but at other times you may need a curator bonus and not a curator ad personam. So we have to investigate those specifically by way of functioning.
Okay. So I was curious about the process that's involved in, applying for curatorship. Who does it? Where does it go to? And are there costs involved?
Sure. So it is a very carefully set out process. Usually it would be a family member who's concerned about a deterioration in functioning in a patient, and they would then bring this to the attention of their doctor, for example. So what is required by the court is 2 medical reports, one of which needs to be by a psychiatrist and generally another from another treating doctor like a GP or a neurologist who's been managing the patient. The process starts by an application being made to court, and generally that needs to be done with an attorney. So once the information is collected, the attorneys would then draft the papers for the court, and that would be submitted to the High Court. The court would then appoint a curator ad litem, and the role of the curator ad litem is to then investigate this application and then the request. And once the curator has done that, he would submit a report to the Master of the High Court, and the Master would then write their own report to submit to the court, and then also looking at who the suggested curator is in the application. The court will then consider this application together with the report from the master, and then decide whether this is valid or not, and also decide on the curator to be appointed, whether it's a bonus and a personam or just a bonus, if that is what is required.
And how long does a process like that take?
It can take a while. So this is not a process that's going to occur overnight. As you can appreciate, you've got to get the medical reports, and then when someone comes to us, we've got to then wait for other reports or request those from treating physicians. So it can be a process, but obviously there may be other legal channels to get more immediate assistance. If I can just add at this point that apart from a curatorship process, the Mental Health Care Act also allows for appointment of an administrator.
Which is presumably a little more easy to process.
Yeah, and cheaper. Yeah. So the curatorship process can be costly and also dependent on the size of the estate. For smaller estates and a cheaper and quicker process, someone who is being managed under the Mental Health Care Act, which generally would be someone being managed by us, could then have the application for an administratorship made.
And what's the powers that an administrator would then have as opposed to a curator?
So the controls are similar in that you've got to provide reports on the estate and then how the finances are being managed. It's just that the curatorship is a much more stricter process, if I can use that term. Although both are very well controlled, and the curatorships are generally also for estates of much higher value because they are a much more expensive process. And sort of the administratorship may be a quicker process.
Okay, and does that then answer to the question that people that may not have the socioeconomic means can still be protected? The costs are less, but affordable for the general public.
And it's especially why it's there is because it's meant for estates that are of a lower value and a lower income per year.
Yes. Okay, so it solves for that.
Yes.
Okay.
And a power of attorney, where does that fit into the process?
So there's always confusion about the power of attorney issue. So a power of attorney is me giving power to someone to manage specific affairs when I'm unable to for various reasons. For example, if I'm traveling abroad and I have a business and those certain decisions need to be taken while I'm away. But the very, very important thing to understand is that someone conferring a power of attorney has to have capacity to confer that power by definition. I can't give power if I don't have the capacity to give it. So I give the power to carry out specific tasks, but the moment I, for whatever reason, lose capacity, the power of attorney falls away. So we often get asked the question, but there's already a power of attorney in place and this person is now losing capacity, can't that just operate as an alternative? And the answer really is no, because the moment someone loses capacity, then the power of attorney lapses, and then the alternatives are curatorship or administratorship.
And I read that you could even be held criminally liable, and often families aren't aware, they have an elderly relative or parent that they're trying to take care of, and they continue running along with the power of attorney, hoping that that would be adequate. And
especially when there's conflict and then there are allegations of funds being mismanaged. And sometimes it's not done in an intentional way, but there's just a lack of knowledge. And then so to prevent that, it's really important to have that revised if capacity starts deteriorating.
Yes.
Is it possible to reverse curatorship once it's been appointed?
Yes, absolutely. So we've done those as well. So sometimes we appoint a curator because someone has a specific disorder that we don't expect to improve over time, like a dementia. And with that, the curatorship would most likely last for a person's lifetime. But there are other situations where, because of any underlying illness, someone is incapacitated and unable to make decisions. So, for example, I've had an example, someone with an encephalitis, for example, and then we apply for a curatorship, but we know that may show improvement over time, and then we would make a recommendation that the curatorship, lasts to a certain time period, for a certain time period, and then that gets reviewed with another examination. And if we find that the capacity has improved by that time, then we can do a report to indicate to the court that the capacity has been regained. The court will then consider that and decide whether that can be reversed or not.
Okay.
And what kind of scrutiny is there for the actual curator that they're not abusing funds? You know, I know you say sometimes it happens inadvertently, but what kind of checks and balances are there?
So they have got to provide reports to the Master of the High Court on the funds and what has been happening with the estate and the movement of funds and other decisions regarding matters in the estate. So there's very tight controls. And in addition, a curator has to provide some security that is related to the value of the estate. So to try and prevent abuse or mismanagement of funds.
Is there times that it goes wrong? Yes,
absolutely. There are times, I'm sure, when it goes wrong, and then the recourse would be for the family member, for example, to then approach the court or the master and then get.
And I read that the curator ad personam, so that individual that takes over very personal decisions, right? Even where you can go, recreation, what you eat, where you live. How frequently does that happen? I was interested in...
Yes. So I think that would be especially significant where someone has very poor or no family support. Like an elderly patient who may have no immediate family and no one who's able to take that role. Generally, we find family members fulfill that role. And in fact, do it quite, carry out those functions even before the whole issue of curatorship comes into question, because they would slowly take over decisions about day-to-day personal care and that kind of thing before we get to a formal process. And generally, those family members would continue doing that.
You mentioned dementia as a common condition that individuals with cognitive decline would apply for curatorship, or for their family rather. What other conditions do we commonly see as part of the process?
In psychiatry we deal with many quite severe mental illnesses, be they psychotic disorders and sometimes injuries to the brain that may cause consequences that impact on a person's capacity. So there are various illnesses, and this doesn't mean that because someone has a diagnosis, they get a curatorship. With any diagnosis, we've still got to do a very in-depth assessment, specifically looking at functioning, because we could take 10 patients with the same diagnosis, but they could all function at different levels. So there are various severe mental illnesses that may qualify for a curatorship, and then we look at those specifically on the background of their functioning, and then make the recommendation.
I was thinking substance abuse and gambling would be particularly difficult conditions for us to ascertain. Is it a curator bonus? What is required for this individual, or if at all, right?
If at all is probably the issue, because we know that sometimes the decision-making can be very flawed, but the decision-making is not necessarily always flawed. They can be episodic based on, for example, the substance use. And that then would not, because that would really be a very restrictive way of managing that. And there are other legal processes that families may resort to manage that.
So on that point, there would be situations where, from the outside looking in, we would see this is not in the best interest of the individual, but there would be no way to intervene in the situation because the person would have capacity.
Absolutely. So I think, there are many instances we come across where we don't necessarily think these are good decisions, but and sometimes the bad decisions are not based on mental illness and not an enduring mental illness. And I think that's where sometimes family members may not understand our decision-making in the process because they can see the bad decisions. But all our decisions need to be based on the presence of a serious mental illness that is impacting capacity. So sometimes bad decisions are not due to mental illness, but just due to other factors.
Because we all make bad decisions.
We all make bad decisions, yes.
So absolutely. What is this prodigal that I read about? Apparently there are people who have capacity but make bad decisions and are considered prodigal in the law.
And that's the legal process. That as an alternative that can happen. For example, when you make bad decisions about your finances and all the rest, because it's also another way to protect someone who maybe, but that obviously stands outside the curatorship process.
Yes, okay. That was interesting.
And if there is disputes in a family, who gets involved? Would the person that did the initial a capacity evaluation be involved again, or would that just purely become a legal matter?
So it, if there are disputes in the family, that would generally come to the attention of the court, and any application for curatorship can be challenged by the patient or a family member who doesn't agree with the other family member who's made the application. That would then go to the court, and the person who's raising the dispute has the right to get alternative medical reports. And remember, as an expert, my role is simply to evaluate the patient when I'm seeing them and give a factual report based on the information I have. Another expert may come to a different decision, but I'm not there to have conflict with my colleague. The court can then look at both reports and make a decision as to what the court thinks is the right way to go.
If there were any changes that could be made to make patients' lives easier or families' lives easier, what would your recommendations be?
So I think education and awareness earlier on, so that the negotiation of this legal process can be easier for families. This process is never easy because while having to deal with these complex legal issues, families are also dealing with the underlying emotional and psychological consequences of dealing with someone who's losing or lost capacity. So I think an awareness of what can be done in various fields, whether it's in the legal field or the psychiatric area. The other aspect is access to experts who are willing to give the opinion. And I think in our world that becomes very relevant. As I mentioned earlier, many doctors and psychiatrists are not keen to be involved in legal processes because of the conflictual nature that it can end up in. So I think access to this type of service is important. The difficulty is that lots of this, if not the majority, ends up being within the private health sphere, which is costly. And then unfortunately, because of resource constraints, it can be difficult to address these types of civil assessments in the public sphere, which makes access difficult.
Because as I understand correctly, any psychiatrist could do the process. It doesn't have to be a forensic psychiatrist.
No, any psychiatrist.
But you're 100% right. We are not keen to do that because we are working in the clinical field.
Yes.
And it becomes a complicated dynamic if this is not what you do every day. So, yes.
But I think that really speaks, just access to various services as a whole.
And it's
sometimes
our whole
a
health
lack
system,
of it.
really.
Absolutely.
Yeah.
Yes.
I was also thinking around, whether we should all be writing our tests of living well, making plans about what happens when we come to this point. If that's also one way in which we can manage potential future loss of capacity, and not just around our mental health, but even medical decisions, right?
I think it's very important to give directives as to what someone's wishes are. Not that that can always be fulfilled, because it would need to stand the test of legality as well. But I think if direction is given to a family member, then they know how to proceed. It doesn't take away the need for a curatorship when I've lost capacity, because if I end up losing capacity and I have a sizable estate, that would still need to be managed. It's not just one decision. And this is a very different process to a will.
Yes.
A will is obviously operative once I've passed away, but yeah, this is a separate process.
So somebody in the beginning of a dementia process could potentially say to family, okay, I consent to that you start with a curator process if I lose capacity. So, but that still means the curator process would have to happen regardless of them asking for it.
It would have to happen, because remember, like we discussed, that power of attorney situation can't last once I've lost capacity. And sometimes, it's possible for someone to, on their own, make an application for a curator to be appointed. If there's insight and there's an awareness that I'm losing capacity and this is probably what the progression of my illness is going to be.
Have you been in situations where somebody has come for a curatorship assessment and the individual is just not cooperating at all?
Yes. Yeah. And unfortunately, the independent assessor ends up bearing the brunt of the anger and irritability towards the family, for example, who are requesting it. And then sometimes, for example, a scenario can be that a family member will go together with the initial medical report, approach an attorney, and then there'll be the request for the psychiatric report, and then the patient is brought through. I still explain to them the need for the process and why it's meant to be a protective process. But as we can understand, the patient is dealing with loss of control in various areas, not just control of finances and estate. It's also about personal stuff, like not remembering stuff and not sometimes not being able to drive anymore, not being able to go to the bank or the shops anymore. And so this is a highly emotional place or situation for a patient. And then you have someone who's in the scary environment doing an assessment that is going to take away more of that. So it's understandable why there's a huge degree of resistance from some patients, but we always proceed from the point of this needs to be, or is a process that is aimed at protecting, and hopefully there's an understanding, but that doesn't guarantee cooperation. As you know, the tests that we can do in the clinical setting that help us to get a more objective view of functioning, and that requires a patient to be cooperative. And I've had instances where patients don't, but we still use what we can get from the clinical interview together with the background information, and hopefully through indirect questioning get an idea from the patients themselves what they are perceiving as difficult at the moment. I always start off with trying to find out what is their understanding of coming to the assessment, and have they noticed any difficulties, and then obviously through that get an idea as to whether they agree with the process or not. It's important early on not to make it seem like a process where you just want to get the information to take away power. So to keep it very general, so that you can develop some degree of rapport with the patient in that interview, and hopefully then encourage a degree of cooperation from them.
Would you ever send them for further testing with an occupational therapist?
Yes.
Or a neurocognitive evaluation?
Yeah, so I think those are very important. Sometimes they come to us with the initial reports, but sometimes not. So the other kinds of investigations that we would do as required. So a psychologist, for example, could do a neuropsychological evaluation that would look at specific domains of functioning in the cognitive areas. And by that we mean things like thinking and attention, concentration, decision-making, and the rest. Beyond that, we can get an occupational therapy functional assessment that looks at specific areas of functioning. And as I mentioned earlier, the whole point of being independent is about how you manage to make decisions in various areas, including your areas of functioning. And the occupational therapy assessment would then give us an indication as to where deficits lie. Now, all these are really meant to show up the underlying clinical opinion. And then together with other special investigations, like, for example, a scan of the brain that may give us an indication as to any major pathology in the brain. What we obviously look for in patients with a dementia is loss of brain tissue or other changes that we see in the brain. And so that also adds weight to the argument that we need to put forward in our reports.
Are there some pitfalls that you've observed that perhaps our colleagues kind of fall into when they're really grappling with autonomy in their patients?
So I think, yes, there are various areas that can become difficult in the clinical setting. I think the most obvious initial one is having to sometimes tell a patient that you're concerned that they're losing their autonomy, and by that we're really implying that they are losing their independence in making decisions about themselves. And that can be a very difficult area to negotiate in someone you've established a long-standing clinical relationship with. It's a sensitive area, and I think it needs to be handled carefully. So maybe the difficulty lies in that sometimes we shy away from making the decision early enough until we're at a very advanced stage. Yeah. And we must understand that, especially in patients with a dementia and some other illnesses, the degree of not cooperating with the process may be worse as the illness progresses. There may be a much better way of or capacity to understand the need for a process earlier on, and then to take the necessary steps. So that absolutely is one. The other is that we need to make independent decisions. And even though families may feel very strongly one way or the other, when we feel that we need to make decisions in the patient's best interest, and that is what we should be doing, it doesn't always get received the way we'd like it to be received, but the area can be conflictual, but it's important to make the decision nevertheless.
And I'm also thinking around, stigma, and that might be a reason why our patients might feel that they don't want the help or need the help, because there's something that lies at the core of, being able to make decisions that, I've got a mental illness. People often link the two, that having a mental illness equals not having capacity.
Yes.
And so it can also be very difficult in that way. Whilst we want to do it from the get-go, I can imagine it's
Absolutely.
difficult to navigate.
I think that's an extremely valid point, because we're often dealing with individuals who've been very independent, especially those who've amassed large fortunes with large estates, very independent, very capable, sometimes functioning in high academic and other areas. And now we're having to negotiate this issue around capacity, because no one's immune to developing a dementia. Any of us can. And so it's an extremely sensitive area to start broaching. I think early on in that therapeutic relationship, it's important to find a way to broach it. And remember, anything discussed there is protected unless it needs to be revealed for a specific purpose. And so to also discuss this with patients so that they are aware, and also aware that this is not information we're necessarily taking outside that space at the moment, but we're rather being proactive in looking at what difficulties may arise. I think the moment there is a diagnosis of something like a dementia, these things need to be spoken about.
And maybe roping in the family early on?
Absolutely. And then with patient consent, when they've retained that capacity, to get family members involved early on with patient involvement as to who they think should be involved in that process. Often it may be a spouse or an adult child, if that is a rational and a reasonable person to be involved.
Yeah, I think there can be lots of pitfalls I can maybe share from my own practice that I've recently had to share with a patient, a diagnosis around dementia, and ask a family member, in this case her spouse, to join. And the outcome of that was actually quite negative in the end, because the family member was concerned and said, you should never have shared this information with us. Where then that becomes a challenge then. I mean, you shouldn't have told the patient, and you shouldn't have told us, and the patient had consented that her husband joins. So it becomes a two-way street here. Who do you tell? How early do you tell? But I mean, we know clinically the earlier we can intervene, the better. But it is a very sensitive thing for people to hear.
It creates difficulties when you've got this degree of conflict, and sometimes either unavailability or a lack of cooperation from family members to, for example, make an application. But the law does allow for any person of interest. So generally it would be a family member, but sometimes it may be a caregiver or an institution, recognizing that this is a vulnerable individual. And remember, we have various laws, for example, that protect the elderly. So we need to work within that large framework of what needs to be done in the interests of our patients.
And the courts obviously would investigate that person, if they're not next of kin, to see if there's an ulterior motive.
Absolutely.
Also, right?
So you've got to make a case as to why. Yeah. So, for example, someone may be placed in a long-term care facility with no family support, and we get a fair number of those cases. Now, we can't just leave that person to their own devices, because an estate would still need to be protected. Yes. And so the process does allow for that.
So, Imran, if our listeners have somebody that they have concerns about their capacity, what is the steps? How do they go about doing this?
So I think often the first port of call, and that is really sometimes often in patients where there's been no contact with any any doctor or caregiver, is to maybe, with your family member, obviously discuss it with them initially if that is viable and it's not a conflictual space, and then go to your GP or any other treating physician that may be involved, like a physician who could be managing for any chronic illness, and then discuss that with them. And one of the important initial steps is to get all the background medical information, and then they would need to see an attorney, because the attorney is the one who would then draft the papers for the court. And then the independent evaluator, someone like me who's doing the independent evaluation, would then be appointed by the attorney to do the independent psychiatric report. And once that is done, the attorney would then complete the drafting of the papers to submit to the court, and then the whole process would take effect.
Fair, okay. Well, thank you. Thank you for sharing a concise and detailed information on such a complicated topic. And I think it would be very enlightening for people to understand how to go about doing this.
Thank you.
We usually at this point have asked our guests what would their favorite meal be that we can cook for them, and then we would cook a vegan version of that. But since you are vegan, you allowed us to surprise you.
Uncomplicated.
So you made this very easy for me. So we are going to give you your surprise now. So just
Great.
give us some time to prepare that for you.
Great.
So your surprise, Indran, are waffles, they're Belgian waffles.
Great.
And they're made by an amazing lady, Julie from Waffle Revolution. I didn't bake them myself. That you can buy from, and she makes all her products vegan. All her baked goods are vegan.
Great.
So these are Belgian vegan waffles with some vegan cream, and then some fruit on top. Enjoy.
Excellent. Thank you. Just up my street. I've got a very sweet tooth.
delicious.
It does. Absolutely.
And then, as a thank you for being here and giving us your time, we'd like to give you a copy of Lunch with a Dragonfly.
Oh, great. Thank you. I look forward to that. Thank you.
So
Tuck
bon
in.
appetit. Yeah, thank you.
Oh, lovely. Nice and soft.
This podcast was made possible with the assistance of Adcock Ingram CNS.